As an infrastructure lawyer, consistent with the conference theme of Highways Tomorrow, I'm going to look at how I think the legal landscape is going to change over the coming years. I've listed on the slide in front of you some key areas of expected change. Now, these are only some. The legal framework is very, very complex, but I think these are going to be the key areas. Innovation and technology in the highway sector is obviously playing a key role. That will change how the legal profession approaches things, how contracts are formed. I think contracts, unfortunately, are becoming more onerous and more administrative. There's going to be new procurement routes, a greater emphasis on collaboration, alliancing, joint venturing. I think there's going to be a drive to improve cash flow, certainly from the government, which is probably pleasing for all. I also want to briefly touch upon some key events and like Carillion and probably Brexit, and how I think that's going to have an impact. There's a lot to go through, so a lot of this will be high level. So, as I said, technology is changing the way highways projects are currently taking place in the industry. We're moving away from designing and building construction projects and moving more and more into the technology space. So the first area of change is how contracts are going to deal with this technology element. Contracts dealing with technology are generally more complex and have a lot more different considerations than what we're typically used to. These contracts will have a greater emphasis on intellectual property rights, software licenses, a greater emphasis on applicable standards, protocols, information requirements, the sorts of additional documents that go into contracts where BIM is being used. I also think there's going to be a lot more provisions dealing with data sharing and certainly cyber security. These are all different concepts that have creeped their way into normal construction contracts. So there certainly is going to be a change in this area. What this means, I think, is that some of the standard form contracts, like the NEC 4, which is a new form that's been endorsed by Highways England, they're going to need to be amended. They're going to need to be changed through the Z clauses. I also think it will result in more bespoke contracts coming into the industry. The NEC 4 suite of contracts, which were published in June last year, have been endorsed by Highways England as the form of choice for future infrastructure projects, particularly the regional delivery partnership framework. But this form barely mentions technology. There's a reference to BIM, and that's it. So significant amendments are going to be needed to these forms. And are we going to see more and more complex, bespoke appointments? I think we will. The second area of change is that, unfortunately, us lawyers believe that contractual terms, the contractual market, is going to become harder, and provisions are going to become more and more onerous. In recent years, we've seen contractual risk pass from the client onto the contractors and consultants, a considerable amount of risk dumping. Due to market conditions, we think that's going to continue. New standard forms that have been introduced, I mentioned NEC 4, but we also have the ACE forms, which the engineers will know, and FIDIC on international projects. These have all been updated recently. They've become more onerous, they've become more administrative. And the standard forms are usually a test as to what the market is doing. So the fact that these have become more onerous suggests that the market is going to change as well. The third area of change is contractual arrangements encouraging collaborative working and collaborative contracting, which has already been discussed in this conference. So building on CDF and other major projects, I think one can expect to see more risk sharing, particularly between consultants and contractors, being that financial pain, financial gain, sharing liability together, and being rewarded together based on project KPIs as opposed to individual KPIs. I think we'll also see more joint venturing, particularly on the major schemes, because that really does work on collaboration and risk sharing. And whilst the government can perhaps be criticised, at least it has been in the press, for awarding contracts to Carillion in recent months, one reason why some of these big major projects have been able to continue is because of joint ventures. The remaining, if I can call it that, contractors or participants in the joint ventures have been able to take over the projects and continue. So I think the Carillion affair demonstrates one of the benefits of joint venturing, and that's going to continue, in my opinion. The fourth area are new procurement routes, if one believes them to be new procurement routes. So in the collaboration theme, the start of this year, Highways England announced a new regional development partnership to replace CDF. Many of you be aware of this. Under this arrangement, contractors will be delivery integration partners, designing and constructing under the NEC4 suite of contracts, which I've already mentioned. Built into those forms are tools to encourage collaboration. Also, the delivery integration partners will be expected to contribute to planned national and regional centres of excellence and the establishment of a sustainable hub. Another example of technology bringing about changes, but also I think this is perhaps an example of practical collaboration, at least in theory. Also at the start of this year, Highways England announced that it will shortly be letting the Area 10 maintenance contract. It's expected that HE will take a lead role in managing route maintenance and the delivery of schemes, whilst appointing a principal maintenance response contractor. On one view, this is perhaps another example of collaboration with the client taking a more active role that it has done recently. A further area of change is the government's push to resolve late or delayed payment. This has become a real issue in recent years. It's something that the government is really working hard on in order to improve payment certainly within the supply chain. Previous initiatives have included a prompt payment code. That doesn't have any teeth at all and isn't working. Payment still is a real issue in the industry. So there are going to be more agendas, certainly from the government, in relation to improving payment. The Construction Act, which incorporates a statutory payment regime into all your contracts, that is currently in consultation. Responses were submitted in January, and the government is looking at the Construction Act to see what statutory changes need to be made to your contracts. One can expect the payment regime to become a lot more simplified, the notices that you need to give and pay less notices if you're aware of them, to become a lot easier to operate, which will be a real positive. The government is also in consultation on the practice of retention monies. And this arises out of the view that many main contractors and clients are unlawfully holding onto retention monies on lots of different projects. So the government's looking at that, and there are all sorts of rumours around about what's going to happen to retentions, how are they going to be held moving forward. So two areas of expected change there, and we wait to see what the result of the consultation will be. The final area that I want to touch upon are particular key events and what changes they have resulted or will result to the industry. Sadly, we think that the Carillion insolvency may have a knock-on effect for other companies in the industry, particularly suppliers who are owed money, haven't been paid because of the insolvency. I do think that the Carillion affair will certainly encourage the government to push the payment agenda, which I just mentioned. I also think it will encourage the public sector to continue with and encourage more joint venturing on major schemes for the reasons I've mentioned. And I've also seen that there could be a shift in that more and more work, certainly where the public sector are procuring projects, going to SMEs instead of projects going to the major powerhouses in the industry. Finally, and sorry to end on a negative, but us lawyers believe that due to market conditions, there's less money, there's less cash in the system. There's lots of work around, but there's a lot less cash in the system. And from our experience, what that means is there's going to be more disputes and more claims, particularly throughout the supply chain, where parties are attempting to recover money that is due to them. So they're the key areas of change that I think are going to take place over the coming years. As I said, there will undoubtedly be others, and these are just my opinion. Thank you for listening. Sorry to end on a negative, and happy to discuss further afterwards.